All right, so we're just getting ready to go on YouTube Live. For our attendees, we're ready to go. It's 3:30, so just bear with us, just 30 seconds. Okay, so let's get started and welcome everyone for once again the KoreSummit Webinar Series 2021. Good afternoon. My name is Oscar Joffrey, and I am so delighted again that you are joining us for a great discussion this afternoon with a great panelist, which I'll give them an opportunity to introduce themselves today. But before we do, I just want to tell you the format for those who have not attended before. We normally do them for about an hour, 45 minutes of us talking. That's right, no presentations. We get a little wild, and from time to time, we do get derailed, and it has happened to us already. So, but bear with us. And of course, there's a little button there on the screen where you can click, raise your hand, and we will take your question and ask it away. We'll give you 15 minutes to ask all the questions from these great experts. And if you want to see the information, you can go to www.koresummit.io. You can see the speakers' information, their LinkedIn link, and of course their email addresses, so you can connect with them directly. You know, we're not trying to create barriers, we're trying to make it easier. So today, I'm joined by two great panelists. I'm going to get them to introduce themselves first, and then we're going to dive directly into the heavy-duty topic. Ladies first, Teresa.
Hi, everyone. I'm Teresa Hyatt. I'm counsel at CrowdCheck. We work on Regulation A offerings, Regulation CF offerings, as well as private placements and Regulation D offerings. I'm excited to be here. Thank you, Oscar, and excited to talk about how we can help you with your due diligence and how to look for pitfalls and make the process go a lot more smoothly.
I like that. Perfect. I like the background, by the way. I like it. It's funky. I love it. All right, Mr. Rowe, the one and only.
Good afternoon, everyone. Jim Rawith in Toro. I'll speak from the broker-dealer perspective in Toro Securities. And in Toro overall, investment bank, broker-dealer, valuation service, RIA, etc. I myself am the Chief Compliance Officer and person that's ultimately responsible for due diligence and compliance. So look forward to a good panel here, Oscar, and thank you for the invitation.
It's always great to have the experts. I mean, today, the earlier session we had was about, what do I need to prepare? And obviously it's always high level, and people are wondering why so many webinars around RegA, because so many questions get asked by clients. And what we've done, with the help of our partners and our ecosystem, we took all those questions and we made them into a webinar. And they do cross, but we're bringing it in from that point of view. I know the other day we got a little derailed in one of them. I do apologize in advance, but it does happen. So today's topic is, what due diligence do I need for a RegA? And this is, at first, some people were, even the ecosystem, saying, Oscar, there's no due diligence for RegA. And I go, well, I'm going to put I call it due diligence to get people's attention, but what it really is that companies need to know what is going to be the regulatory compliance items they need to have prepared and ready for when they go in to do this, to file the Form 1A. We keep using the word Form 1A, and I was leading that in the last conversation. People keep thinking Form 1A, Oscar Joffrey, sign my name, and I get filed. And we're going to demystify that today with Teresa. And of course, the broker-dealer. The other question I get asked, broker-dealers charge a fee. I mean, what do they really do? What are they? So we're going to uncover those two items in depth, because I think it needs to be, for the audience today, you need to appreciate the amount of work that they're going to do for you. But more importantly, is to inform you what you need to do to be prepared. So we're going to start with the legals first, and we're going to hop back and forth from there. I'm going to put Teresa on the spot because, so in full disclosure for everyone, CrowdCheck is my law firm as well. So in full disclosure, everybody we work with here, and I'm going through a RegA. So I know when I got that list from Sarah, my jaw dropped from here to the ground. and I'm going, I need a session just on that. I mean, you call it the RegA questionnaire, right? So tell me what's beyond. I see it as a due diligence, but let's start with that.
Well, it is a form of due diligence. It's also a form of getting your documentation in order so that it's easier to prepare your Form 1A. The Form 1A, as you mentioned before, that's the document that gets filed with the SEC, and it has a lot of items in it that require everything from executive compensation to just a plain old description of your business to risk factor disclosure in your financial statements. But going back to the checklist, it is a lot of documentation. Not all of it applies to every company. What I like about it in particular is it gives me a chance to really get a top view of the client before I've even had a conversation. But more importantly, it gives the client a chance to really think about the offering statement that they're preparing and think about who their stakeholders are. If there's one common denominator I've heard from clients that are approaching Regulation A, it's that they really wish that they had thought about getting their stakeholders on board early in the game to kind of smooth the process over. So when I talk about stakeholders, I'm talking about, in particular, let's say, as a lawyer, I always say, go start first with your contracts, go to your material contracts, go to anything you have with vendors, with suppliers, manufacturers, go through those, see what they have, what information is in there. Is there sensitive information? Are there trade secrets? Is there, and not just from your side, look at it from your counterparty side and be aware that those have to be filed if they are material. We can talk in more depth about that, but I think that's a good place to start. And also be aware that as you look through that, if you have to approach a particular counterparty about this contract and say, hey, we may have to file this with the SEC. Are you okay with that? What do you see in this contract or agreement that has that's sensitive for your company or for your business? There may be a lot of back and forth on that. And some counterparties, believe it or not, will seek to take leverage over that and maybe renegotiate a few terms or a few items. So it's good to be aware that that's a possibility.
It's a great comment. You know, when I receive the checklist, and I mean, I'll get to you, Jim, because obviously the broker dealer will have a somewhat of a similar, obviously not duplicating, but it's 57 pages. I mean, I'm just looking at ours right now as we're preparing. I'm going. I mean, it is. If you're not prepared for it, it will catch you off guard because you have this mindset in your head that, you know, because we've been simplifying it. All you got to do is file a Form 1A. I mean, I hear ourselves in conversations with clients, right? All you got to do is, retain a lawyer and form your Form 1A. They can do it in 30 days, 45 days. But it's a little bit more than that. You touched on it a little bit on the agreements, but it's digging deep into all aspects of the business. From what I can tell, can you go into more detail? We're not going to go too deep in, but all the high level points, because I think it's important for the audience to understand being prepared to come to law firms like CrowdCheck is critical for them to get to A to B quicker, right?
So that brings an excellent point up. One of the other pieces of it is, you're right, it can be overwhelming. In particular, for some reason, it seems to be a difficult point is the capitalization table, getting that and your meeting minutes so that everything jibes together. Because most companies, most startups, most small companies end up paying equity to employees or to consultants in order to, one, they want to conserve cash or put the cash into the business and give people an incentive to help grow the business by giving them equity. If you're not keeping track of that, you could have problems. You may not know how many shares you have left that have been authorized on your initial articles of incorporation or certificate of incorporation. That can be a problem. You may not know where your shares are or who has them or how much they're outstanding. And one of the things that CrowdCheck does is we really try to make sure your capitalization table is thorough so that you aren't going to run in that problem. And we also go through your meeting minutes, make sure you have the board authorization and board consent, and where required, the shareholder consent as well for the various authorizations and issuances. So that's one piece of it. And it is a big piece. That is a lot. I will confess, I've spent probably more time than I want to confess, staring at capitalization tables and going back and forth between documents and trying to make the numbers add up. That's a big piece of it. The other piece of it that is a lot, I find, is the testing the waters materials. This is another stakeholder you want to get on board early and make sure they understand the rules. That would be your marketing folks. They spend a lot of time carefully crafting and designing materials to make your company look great, to have your brand out there and have it be distinguished. And all of a sudden, you approach them with these very large legends that are all caps and can really muck up their artwork. And that can be frustrating for them as well. And so you need to keep track of that. One, they need to know what that is, because as you proceed through the 1A process, those disclosure requirements, the legends and links that you have to provide, it changes. So it's really important to have those folks on board so that they know what they have to include and when they have to change it, and they know to run it past either in-house counsel or run it past us.
Okay. I'm going to get back to you because I'm going to get you some time to go through that massive checklist you guys gave me. So thank you. I'm very happy. I'm ecstatic. Thank goodness I gave it to Jason. I laugh because, I'm lucky I get to assign it to someone. So Jim, I'm going to come to you because, the broker-dealer role in RegA up until recently has been, I think in better words, it's been treated as a commodity. And it's sadly so. It was done because people didn't truly understand the value. So we're going to talk about the value of the capital raise, of course, where it brings in. But at the beginning stage, what part are you undertaking to look at this company that you're bringing in? Obviously, the law firm is going to do a heavy load. What more additional is the BD going to need in order to satisfy your requirements?
Well, many of the things that Teresa and her shop would need, same things we would need, right? So there is a fair amount of duplication. Reg A does differ from a Reg D or Reg CF offering, or even a public offering. Every exemption has its little quirks to it, but at the end of the day, a lot of the material is the same. For us, we still have to do a lot of the, checks and background activity as well. You're not released from FINRA and the SEC about, KYC and AML and, all the rest of the things. You still have a lot of those duties to perform. Your point about, commoditization is an interesting one. You're right. Historically, the broker dealer just did kind of, very simple task, and it was kind of left to the issuer to raise their own funds. But the differentiation between broker dealers, some offer different services. We do some things that are different. So we do a little bit more extensive due diligence and compliance work than maybe some others. That can be either good or bad, but broker dealer record functions a bare minimum. And that's usually what you're applying with the commoditization aspect of it, but that's the bare minimum.
But what else are you looking? I guess maybe let me be more specific. And I brought the subject up because somebody in another webinar asked something really interesting, and I didn't have an answer. I really didn't. And I even said, you know what, I'm going to create a webinar. And even Sarah was asking me, what you doing? What are you talking about? I said, it was an interesting question, and I think it needed, we talk about preparation, but what are we preparing for, right? So this is, what are we preparing for? So I get the broker-dealer record, but from eToro's point of view, I come to you, you obviously know I'm with Project. Okay, that's great as a lawyer, but from a broker-dealer, you have some fiduciary compliance requirements you need to meet as well. So what do I need to come to you with prepared? Because remember, I haven't filed my Form 1A yet. The reason I'm talking to you is because I want to do that, and you need to do your work as well to satisfy your requirements.
Well, look, there's for any offering, you always have to have, know your client, know your customer rule, right? So you want to know what the background is of your customer. And unlike a public offering or anything else, when you're doing a Reg A, Reg CF, or D, you're much more reliant on the management team. So the success and failure factor is much more reliant on that individual or that management team to be successful. So a lot of assessment goes into both the hard and soft components of that assessment. So, but a lot of it can be just background checks and kind of the starter kit for that. So to me, making sure that you do good work on the front end is critical. And then also, you know, from a broker dealer's perspective, you can maybe have a mistake or overlook certain aspects, but if you fail some of those early, you know, customer hurdles, that's inexcusable in their eye.
Yeah, of course. And obviously this is the part that, you know, some people, we don't skip it. We don't go into the details of it. And obviously, Teresa, you touched on it, on the legals, which I think it goes back and forth between the two of you. This is something that why I specifically brought a lawyer and a broker dealer to the conversation, because up until
one thing
recently.
Can I make a point though, Oscar?
Yes,
you know,
yes,
I mean,
yes.
I know you got some points to make as far as moderating, but you know, the one thing that you can never stress enough is, you know, prior planning prevents piss poor performance. And I'll say that 10 times in this you know, webinar. And I've never seen, and I can tell you, I've seen some great management teams and they think they've got it all perfect. And there's no one that's ever had it perfect, ever. In the recorded history has anything ever been ready to go. And there's always something. And you know, I give a hat tip to those groups that get pretty close, but it can take, I mean, I've seen groups think they have it right, and the ones that jump up and down and swear to God they have it all ready to go, they're the ones that are 6 months later still trying to figure out how to get to, you know, question 12 on a, you know, 200 point questionnaire. So it takes a lot. And, you know, people, to Teresa's point, you know, there's a lot of things on those checklists and it takes a long time. I mean, if you've been missing some minutes, you got to go back, you got to make sure everything's in order. I mean, these things take time. And obviously it's some of the things you learn, you know, when you're younger, you know, a little bit at a time, all the way along, you know, do your homework a little bit, all the way through, and don't try to jam it in on, you know, the night before the test.
Agreed, Jim. I think that's a great point. You know, planning. I think this is an area that why this particular one we created is because we felt that we were getting right to the point of saying file a Form 1, but we weren't really telling you anything. And what we're now stressing is that, you know, come prepared, and there's always going to be other things, but these are the basic requirements you're going to need to have. And, you know, Teresa touched on it, the contracts. That's an important one. It never even dawned on me that having a material agreement with another party, and it's rather interesting that you bring this. I just shared this with my last panel. I had a client. We have a client. We have a client in the real estate space who filed a Form 1A. I didn't recognize the lawyer, but they came to us and all that, and they go, "Can you create an invest button for us? And you be the TA and all that. But I want them to sign a non-disclosure agreement before they can view the remaining deal." And I'm going, "Excuse me? It's a Form 1A. The data is already in Edgar." And he goes, "What are you talking about? It's in public information. I already pulled your filing. I already got." "How's that possible? How did you get it?" It's like, okay, come prepared. To your point, these are all the little wake ups. But there is one question I'm gonna put you in the spot, Teresa, because, you know, part of the I'm not going to blame CrowdCheck, but I think part of the commodity aspect that happened in the broker dealer community, part of it came from, that's the regulation required to have a broker dealer. We all know the answer is no. That isn't the issue. The issue now is about best practices and ensuring a proper offering to get to there quicker. So in your view, does bringing the broker dealer in early during the draft phase, bringing the broker dealer to uncover, because the broker dealer will also do their due diligence, that items that you may need, will that assist you as well in the process?
Absolutely.
Okay.
Absolutely. We work together. It's crucial because broker dealers often, I can't speak for Entoro. I know they're a terrific firm. but I have not had the pleasure of working with eToro yet. I look forward to doing so one day. But the broker-dealer, in my experience, has been heavily involved in helping the client figure out the offering terms and what makes sense for that particular company. They're also good at helping them with valuation and trying to figure out share price, or if they want to offer perks or discounts or bonus shares. The intermediary platform or the broker dealer can be tremendously helpful. And that is crucial on my end, because try writing a document when you don't know what's being offered. It's, that's like trying to write the document without having the financial statements in front of you. It's a key thing.
Yes, it definitely is. So, okay, so we've talked, obviously, so if everybody's listening carefully here, so what has changed from our dialogue from over a year ago, 2 years ago? We're now saying how imperative it is to have the broker dealer, because they do get they have a fiduciary duty to look for things like bad actor. Jim, are you doing a bad actor check as well with, you're doing that as well? So does it make sense to coordinate the efforts with that with a law firm? Or Teresa, I'll put you on the spot. Is the law firm doing the bad actor check, or is that something you rely on the BD to do?
Well, I like doing, I like doing bad actor check. I like doing a lot of things on my own, just because I always feel that there's a few things that are worthwhile making sure you do. As I mentioned, background checks, bad actor checks, some of the things just to make sure you, like I said, you can have a mistake with FINRA and the SEC on the financial thing being inaccurate or something like that. But it's if it came down to someone that had a track record of fraud or securities violations or anything, and you didn't catch it, and it was something wasn't disclosed or something, that's the one that they'll hang me for sure, right? And those are the ones I like to double check, triple check. I mean, those are the low-hanging fruit in my world, to make sure you do a good job on verifying. As far as some of the other things that can be, look, everything's important, but there are orders of,
Yeah, there are, but that's a big one. I mean, we don't think about what is a bad actor check, and you're doing it, and that's great.
Well, I mean, it's people, even in today's age, I've had people, you go through a thing, and I've had one guy that, I was kind of cruising along and kind of looks like it's okay, and you just kind of come to find out the guy not only had been convicted and gone to jail once, but twice for securities fraud, right?
Oh,
so
Jesus. Okay.
you don't, you'd let somebody like that slip through. What the heck is FINRA going to do, or the SEC? They're going to look at me and go, what, right? So
yeah, CrowdCheck does. Oh, sorry.
You can't make it. You can't take anybody's word for it. You can't trust anybody in this category. A lot of issuers feel offended, all that kind of stuff. First of all, don't worry about it. These are regulatory things, and just, don't get your panties in a knot. You just got to, these are steps you have to take, and we have to do them. And it's just good practice. Sorry.
Yeah, sorry, Teresa.
No, that's okay. That is something that CrowdCheck does. It comes with our verified and foundation reports. It's a very key piece of information. One, it is crucial, as Jim pointed out, just because you need to know who you're dealing with, and you don't want to turn someone loose like that in the markets, taking advantage of people. And you don't want to get in trouble yourself either. Also, you want to run this because it determines eligibility. You cannot do a Regulation A offering if you have something in your background. There are certain things that the rule covers. If you have had a securities law violation in the background, that's you can't use these exemptions. That's just the way it is. So it's wise to look through those. And I find them also helpful. I find it interesting, Jim, I've had the same experience where people have been offended by this. It's oftentimes I'll get this document request back, and we attach certain authorizations, including the bad actor check, to the back. And when you ask for it, there is a certain amount of offense, and they're like, well, what if there's something there that disqualifies it? And I'm like, you would know. They're like, well, what if I don't know? I'm like, you would have had the worst day of your life. Okay. You won't forget that.
You won't forget that.
Yeah, we're not looking for your parking ticket or the speeding
I'm just
ticket.
going to say that. Thank you. Yeah. On that topic of bad actors, so let's define who would need to go through it. So for sure, all the management, board of directors. And what is the percentage of ownership in a company that would need to go through it as well? So that's another component as well under Rule 503, right?
Yep, that brings us back to the stakeholders. So you want to go talk to anyone who's a 20% holder. And interestingly enough, if it's an LLC or a partnership, we're going to not just look at the entity and run a background check on the entity, although we will do that. We will look through them to whoever is the control person for the LLC or for the partnership.
Thank you for that. So
we'll continue up that chain till we finally hit flesh and blood.
Thank you. So, and the reason it's good for everybody to hear this, if there are any Canadians, see, I'm picking on Canada because in Canada, we're known for hiding behind companies, and we've been able to do that for years. But under this regulation, you'll keep digging and digging and digging. Ah, there he is, Joe Smith, right? If there is a Joe Smith out there, I mean you. So anybody over owning 20% or more, the board of directors, the senior management team, and senior management team meaning C-level officers, correct?
Okay, well, it can be depends on how they're defined, right? I mean, it could also be somebody that's a senior vice president of finance or somebody that may have control of a checkbook, or depends on, you have to use common sense.
Yeah, of course. It's just that, how people are. Does it exclude John? Does it exclude Joe? He's a director of marketing. He's not really up here. So it sometimes it gives better clarity. So we've covered the contract, the cap table, the team, the bad actor, working. So what other elements within we're constructing this massive document, right? It's bits and pieces is the audited financials. Obviously, you guys are not auditors, so we're not going to go into there. They're going to do their own digging.
I would like to bring something up. I'm sorry to interrupt, please. Oscar, just something on the finances. I'm not an accountant, but something that I would like to mention is if you're going to be, obviously you have to have audited financials for RegA offering. It's better to start the process early and just be prepared that even if you've had reviewed financial statements, for example, if you've done a CF offering, they are going to look very, very different because the rules are going to treat your finances differently. So your reviewed financial statements are going to look very different, or could potentially look very different as audited financial statements. The stock compensation that I mentioned earlier that you're paying to people, consultants and employees to get them on board, those have to be expensed now. There are a number of things that can really change the look of your financials. So another stakeholder you want to keep informed and make sure they are aware of what's going on with your company would be your bank. If you have a credit facility, if you have lenders or even people holding debt securities, they might look at these new financial statements and say, hold up, and you may have to have a conversation with them about how the fundamentals of the company haven't changed. What's changed are the way the rules apply to the company.
That is, it's rather interesting, and I've heard this before from your firm, from Andrew, in other conversations, talking to your stakeholders, and people think of stakeholders, your shareholders and your staff, but you're going beyond that. We're talking about partnerships, other arrangements, financial arrangements that could be impacted by your RegA offering, because it is filed and it is made available to the general public, right? And a lot of information gets disclosed that some people may not want, but it may change the whole playground that, whoa, this is not what I thought it was.
Transparency is key. And, that's really key. Management needs to understand that their employment agreements for like the CEO, CFO, their employment agreements, any agreements with the directors, those, certainly with CEO, those are going to be filed. Yes. If, any related party transactions, if you have relatives working for you, and if you trip the test, I think it's like 1% of assets or $120,000 for a tier 2 Reg A, Now their agreement has to be filed, and you have to disclose it and describe your relationship to them in the offering statement. And some people, believe it or not, don't want that known. Marriages have been outed.
That's right. I'm taking an annual salary of $1, but my wife is taking. No, you guys haven't heard that before, have you? No, that's a very good point. See, it's this is part of that preparation element that comes in. So I'm going to come back to you, Jim, right now. So, the bad actor is one element. What other specific things are you what do I need to give you? I'm doing a RegA. What else do I need to give you? I mean, I haven't filed my Form 1A yet. I mean, so you need to get some comfort as well. Obviously, the company goes, well, what's your fees and all that? But it's not just that. You need other things. What other specific items?
Well, for me, it also depends. I mean, just doing the basic, compliance materials are one thing. If you're also looking for us to, be a active placement agent as well, I'm going to be looking for a real, a different kind of equity story, and I really want to know more than just what's kind of the standard material. So to me, I want to hear the equity story as well. So I have a lot of interest in really understanding that history. So that's kind of beyond and above just the basic due diligence. If you're looking from, if your question is specific and only to the due diligence aspect of it, Teresa's her list is going to almost be mirrored exactly to what mine is. So in fact, hers is probably slightly more extensive than mine. So
on that point, can I ask you a question here? I'm not, if I am working with CrowdCheck and I'm now being introduced to you as a broker dealer, does it make sense, instead of me duplicating? Obviously, this is the other issue that I want to help entrepreneurs, right? And knowing that everybody needs this information, is there any issues with the law firm giving it to you? I mean, that's a level of trust, right? Does it matter who's giving it to you as long as you get it?
I actually like it coming from if it's the same material, I don't mind it coming. I actually would rather receive it from the management team myself. Okay. And it's not that I just trust the law firm, quite the contrary. I would rather have it come from the management team.
Okay, so
I know that sounds crazy, but I would rather have it come from the management team.
Yeah, and what I'm trying to get at is, today.
I mean, if it's the same data room, let's just say there's a Google Docs or there's a VDR that they've compiled and they've put all of their stuff in an organized form, which would be, I think Teresa and I would both do cartwheels. But let's just say that there was somebody so professionally organized. And you can pull from that same data source, fantastic, because the things that I'm going to have, she's going to need the same thing, but I have to retain those same records. People say, well, can't you just get it from them? Well, we have to, as a FINRA licensed SEC regulated entity, we have to maintain those records ourselves for 6 years. So for FINRA audits, so I have to maintain my own separate records for those. So an issuer doesn't appreciate it, but we have to have those.
No, believe me, we appreciate it. See, now I'm going to speak as an issuer. It's not an issue of not understanding why you need it, and the problem I mean, today the panel was about how big of a team. We're seeing a lot of one-man shops, right? Well, I mean, one person deal.
But it goes back to Oscar. This is what I'm advocating, is that instead of having it out of a shoebox in one file cabinet, there's plenty of ways to have it organized in a filing mannerisms. And whether or not that list comes from somebody like Teresa's shop or ours, we actually have, there's only so many ways you can do due diligence, and so only so many. I mean, I think ours is a 12-folder process. Real basic financial statements. I mean, you go through. Teresa's going to have a similar list. I believe I've seen theirs.
It's 44 pages. I'll just put it down.
Okay.
And counting. But
the basic concepts are the same. Whether or not we're splitting hairs here, but the point is that if someone is organized, it doesn't matter. You can get them filed and what have you. Now, we do things a little differently from the broker dealer. We like to actually what we do is encourage our issuers to upload it into our system directly. So we actually have an online portal ourselves that I actually encourage the issuer to go and then upload it directly into our system. And I like that for two reasons. One is they can see exactly what they have filled in, so they can take ownership of that. Also, no one can say, I emailed it to you, and I'd rather not at all sitting in an email anyway. I'd rather have it uploaded directly into the system, and it's just much more secure and it's much easier to manage. And given all the cybersecurity issues, et cetera, I'd rather have that structure anyway.
No, this was very helpful, and I do concur with all of you that. So I'm glad to hear that, and I got a smile on my face for a reason. But I'll tell you guys all, it wasn't here to be a product placement or anything like that. But so continuing the discussion, obviously we've dove in really nicely. I like this because I think it's now clear to people that these are the elements, but again, you need to share, you need to give comfort to everybody. There's a due diligence and that needs to be done. And we're calling it due diligence from the legal side, but it's actually, they're collecting all this information so they can file your Form 1A in a way that they understand the business and the structure of the company, make sure there's no pitfalls or anything like that. So I want to spend a little bit of time, Teresa, just you've given a couple of examples of some of the things you've seen that could have been prevented. I was wondering if you could share, without obviously sharing any company, of course, privilege, but in general, what are the other things that companies can watch out for? So you mentioned agreements, you mentioned the cap table, you mentioned the 2-year audited financial statements and all that. What else could you think of that you've seen that kind of gets derailed during the process?
Well, making sure that you have the correct corporate entity. If you are an LLC and you want to go into RegA and issue common stock, you need to think about how you're going to change yourself from an LLC and then reincorporate into a C Corp or a regular corporation. Are you in the right state? Are you in a state that you would rather be in Delaware? Or your corporate counsel advises you moving from one state to another state for whatever reason, maybe something in particular about your business. But yeah, look at your corporate entity, make sure you're in the right place and in the right vehicle.
Can I echo that, Oscar?
Yeah, please.
Like there's, and I'm not going to name the state, but there's one state I won't even sign an NDA under. I totally echo that. A lot of issuers just kind of, they'll either form their entity, LLC or Corp, in whatever jurisdiction they're at without giving a lot of thought to it, because that's where they live. And it really impacts things negatively when you're coming to a capital raise. If you're not sure what you should be doing, the default is always Delaware, and in my opinion, the default in the future should be Wyoming, but that's a whole other argument we can have. That's a separate discussion. But there's other friendly jurisdictions out there that I think are good to have, but the default is Delaware. I think Wyoming's a great jurisdiction. Other ones that are pretty good, South Dakota, there's Nevada, there's Texas. I mean, there's some that are good. And then I have a list that I just, and then some states have a good history in Maryland for REITs. And I mean, there's some, there's a couple, exclusions and, differences there. Teresa's better equipped to articulate that than I am, but there's just there's a couple states that are no-goes, right? And I won't get into that right now. I don't think that's appropriate for this dialogue, but just
no, I think it's great. I mean, we've added another item again that I've never even thought of, that you said it's structure, or where you incorporate it. What are you, LLC or the jurisdiction?
You and I've talked about this in prior webinars. I think there should be, you could do a 2 or 3 part just webinar series, right, or structuring series on, really the intricacies of things. I mean, just embedding options, optionality, theories, real options, structures. I mean, these things are a little bit of a lost art. and a lot of people really don't know what the hell they're talking about. And people just kind of take the flavor of the day, and they really don't understand the depths of it. It's kind of, they just don't get it. They don't understand the long-term implications. They don't understand. Anyway, I'm kind of passionate about structuring.
No, listen, it's an important part. The deals are going to get more complicated now. We started with vanilla. We added a little bit of sprinkle in the last few years.
But
now we're really going to get something different, right?
But you know what? Vanilla sells, man.
No, I know, I get it.
So do sprinkles.
Little sprinkle. We're now able to raise 75 million, so we're going to get a different type of issuer that is wanting to do not so much something different, something they've been accustomed to. But if you want to sell it, let me be selfish. If you're the issuer or you're the broker dealer, I mean, Teresa can paper anything you want, right? That doesn't mean you're going to sell it. Okay, she can put 50 boxes on a piece of paper. I used to do that in a prior life. I could structure any damn thing in the world. I mean, I can make it so complicated you couldn't figure it out in a month of Fridays. Okay, but good to know.
Doesn't mean you can sell it. Okay. And if you
I didn't know you did
it,
that, Teresa. I'll make a note of that.
I don't do that.
But if you can't sell it in 45 to 60 seconds, you can't sell it with 3 bullet points and 5 words per bullet point, and you can't sell it to your grandmother with a piece of paper and a pencil, it's too complicated. Okay, so you got to be thinking about who your buyer is and respect their concepts, their ideas, and how sophisticated it is. This is a RegA. Okay, this isn't, you're not in a $1 billion corporation, doing, all kinds of, options, and, you got to think about who your buyer is. You got to think about, I'd undertake the KISS theory myself.
I think, I agree with you. We got to keep it simple, without a doubt. But Teresa and I have had the experience now working where people without thinking, and again, inexperienced counsel can get companies into trouble as well. I mean, that's another thing we all need to pay attention. That's why part of this is uncovering what you need to be prepared. And I think you're right, Jim. We are going to do a webinar series just on structuring, because structuring is not just about jurisdiction. We noticed a flaw immediately when somebody wants to do a RegA and wants to issue warrants. I mean, that's one that nobody saw coming. Luckily for CrowdCheck, they were experienced and they knew what they were doing. I've seen it in other cases where, it's, and again, why is that important? Because it's part of the structuring, how it's dealt with. And so it's part of all these different elements that when you're coming to this table and you're coming with your contract, your cap table and all that, you also need to come in with your proposed terms, because that will also have an impact on what they're looking behind. Like does that make sense, Teresa?
It does. I wanted to add a point here, though, and obviously, issuers, companies, they're my client. I represent them. But at the end of the day, for all of us, whether you are the broker dealer, the accountant, the client, the attorney, the stock transfer agent, whoever it is, let's not lose sight of the fact that when we sell these securities, we are selling them to people. And as I tip my hat to Jim, because we're talking about people with varying levels of sophistication who are out there looking at these documents. And I agree, keep it simple. Clear disclosure is the best disclosure, because not only does it help the investor, that also protects the client or my client. It protects the issuer. It protects everybody else as well. The accountant, it protects the broker dealer. If you have good disclosure, clear disclosure. And I think that's really, at the end of the day, what I like to think is I'm playing a fundamental role in serving that need.
Oh, I agree. And it's interesting that as an industry, as an ecosystem, we're now moving in that direction. Quietly already, it's already starting to happen. The industry, some of the participants are already talking about best practices. And to your point, these are things not the regulators are mandating us. We're doing it because it's for the greater good. This thing has got such great momentum. They increased it to 75. Clearly, we want 100 million and we want more. But we need to step up the game in all different aspects of it, and helping companies. And these webinar series are going to definitely help people out. But right now, I want to give everybody an opportunity who's here. There's a button right there below. You can click, raise your hand if you got some questions regarding, from Jim, from eToro Capital, regarding what a broker dealer needs, or from Teresa from CrowdCheck regarding, the other lawyers preparing your offering, and what items you need to have prepared. And again, we're going to continue talking until I see somebody's hands goes up. But so I'm going to throw another one in here. So you guys don't think I'm ever ready, but I am. So now I think it was pretty simple that up until now, the entire scope you were looking at was, I'm an American company. So now I'm going to throw in a loop, a Canadian company, into all this. And the reason why I throw that in, because obviously the regulation allows both a US and a Canadian company to proceed. And in Canada, there's a lot of the stuff that America needs that is never required or ever been to provide. So it's a wake-up call. But what additional items from a legal side do you think a Canadian company, which in this case would be considered a foreign issuer using the regulation, which it can, do you think it would be needed as well, along with all of this items that we've already spoken?
Well, the form requirements, as far as I understand it, I mean, Canadian companies can use international financial standards, IFRS, for their financial statements instead of US GAAP and US auditing
IFRS
standards. So you have that. I'm not aware, and this could be my downfall. There might be other places where Canadian companies get breaks in the disclosure, but I have not.
No, I don't think they should. But I'm really curious how you guys do a bad actor check on a Canadian.
With all your privacy laws.
Well, that's why I'm asking. I'm bringing it out because, see, in Canada, you can commit a crime in British Columbia, move to Alberta and do it all over again. Nobody knows about it. Go to the next province until you can hit all 13 provinces and nobody will ever know. So I'm rather curious because one of the one of the things that CrowdCheck does, right? Of course, you'll speak to legal counsel in Canada of the company, right? That's I believe that's one of the requirements, but what other elements do you need in order to satisfy? I know the financial statement, IFRS, but is there anything else you need from a law firm perspective, bringing this client on that is now not in a soil where you can easily get the information you need to satisfy your requirements? Teresa.
Well, when we run a bad actor check, we have a database that we use. Or multiple databases where we enter the person's name, date of birth. We don't take very sensitive information, but we do want like a name, date of birth, address, because some names are very common and you want to hopefully not have to peel through 25,000 pages for every John Smith. Presumably those, again, I have not represented a Canadian company, but presumably those go through. I mean, I just won't go to Canada. If I'm going to get picked up at the airport.
It's just that Sarah's done a lot of Canadian
because
clients.
I did a bad actor check. So much for Montreal, Oh, well.
Yeah. They'll
I'll
mail
actually
you
have
at the
to go
border.
to real France.
Oh yeah, oui. All right, Jim, on to you. I mean, you've been in our waters, so.
I'm not. Sean's actually working on a couple right now, so he would have a better say from our team right now. Me personally, I haven't worked one directly, so I'm gonna have to punt on that question myself, Oscar. I would
no problem.
do disservice trying to guess exactly what that would be. We have been working on them. I just can't say exactly what the specific details are.
Yeah, no, I have another panel on Canada. I just thought I'd throw it in there because, I mean, these are the two primary jurisdictions that can use this regulation. And Canadian companies, you still need to do all the things we discussed earlier. You still need to have your contract, so your cap table, your IP. And I think one item that Teresa mentioned, that on your cap table, if you've got a holding company holding they're going to want you to dig deeper. And this is where it gets a problem in Canada, right? So we do have a privacy provision. And so if you're in British Columbia, it's okay. If you go to Alberta, it's not okay. If you go to Saskatchewan, so every province has got a different rule about how far they can, so they haven't standardized it. So, and a lot of the times that's what certain parties do. We found a RegA offering that had a Canadian bad actors, but we knew the entity. We knew it from historical records. Don't ask me how. This brain just kind of and then I just started Googling it and I just remembered it. We have a bad actor database that the regulators publish, but it's not picked up by any search engine. It's prohibited to be picked up by search engines.
How is that helpful?
Don't you just love investor protection in Canada? Yeah, it's so that's why. Okay. You can have somebody hopping from province to province, and that's where the regulators are. I mean, it's interesting. It's got its pitfalls, but that being said, the requirements still need to be met for the U.S., regardless of all that. And you need to deal with it as the way you said it. If you got sensitive contract agreements, you got to put it out there because otherwise you're not going to get through, right? Regardless of where you're from.
Well, you have to analyze, is it, there's a difference between material agreements that are outside the ordinary course of business, like a significant asset purchase. That's one thing. Another thing, if you're talking about the 3PL company that does, your packaging for you, or if you're talking about some type of a manufacturer where there are sensitive specifications in the agreement itself, when you drafted it, you're both private companies. You want to make sure they manufacture it the way you want it manufactured. So you put the specifications in the contract. Now your circumstances have changed. So you have to think about that. I'm harping on that because you have to look at this. Some companies might come back and say, yes, but it's a material agreement, but it's in the ordinary course of business. So I don't really have to provide it. Take it down another level. Okay, so it's a material agreement, but it's in the ordinary course of business. Is this agreement were to suddenly be canceled, or if something were to happen with that particular supplier, vendor, manufacturer, whoever, how easily could they be replaced? And even if you replace them, would it cause a disruption in your business? Would there be a problem with supply? Would you have a problem with inventory? That in itself could make something that could overcome that whole ordinary business into the point where, yeah, it is really material and investors do want to know. They may not have an interest in knowing about the pricing or how things are stitched together or what kind of paper you use in your packaging, but they do want to know. They will want to know if you're kind of hanging in the balance. If that agreement is coming up for renewal, I mean, that's something else. That's a big thing. When you look at your agreements, when you look at your contracts, even your insurance policies, look at the expiration dates, your license, your permits in the different states and for the various jurisdictions. When do they expire? You want to get ahead of that because that's a last minute headache you don't need. You're trying to run a business. You're trying to assemble all these documents and build this offering statement. You don't want to have to suddenly go back out and go, oh, I forgot to renew my insurance for my, whatever kind of insurance it is, whether it's a general services insurance or, my employee disability insurance. I forgot. You don't want to lose track of things like that.
No, it's a great point. I've been taking notes like crazy because I obviously in the document I have, I think it's all there, most of it, but I think that what I really got out of this, there's some really important highlights that need to be highlighted and to understand the importance of it. Because when it says material agreements, like most people, not one, you need to give a definitive answer to it, but not only that, you need to provide an explanation to that, what that means and what the impact would be. Because somebody will say, oh yeah, I got an agreement with that company, we got an arrangement and this and that. And they may not realize that the terms of that are going to get inputted in the Form 1, and then the next step, it's going to be in a public file document. I'm correct because it's an exhibit, correct?
Yes, it's an exhibit. It's going up on Edgar. Now, you can always seek, well, you don't have to do it anymore. After March 15th, you can get confidential treatment. That is changing as of March 15th. So it used to be would have to redact the information, which you will still have to do, but then you would have to submit a letter seeking confidential treatment to the staff that hit certain legal standards and had to make certain arguments, and the staff basically it was, you had to demonstrate competitive harm. And that's not always easy to do, though. I mean, that's kind of an elusive, that's an elusive piece, that's an elusive standard in a lot of ways. So now it has been simplified quite a bit. So what the new standard is, it's not about competitive harm. It's that if it's the type of information that is both customarily kept private and is actually kept private. So they're treating companies, maybe I shouldn't put it this way, treating them more like adults, like grown-up people know what's appropriate to say in public and what's not appropriate to say in public. So having said that, bear in mind, the SEC staff has Google just like anybody else. So if you're trying to keep something out of the public domain, make sure it's not in the public domain. A
great point, especially when people say nobody knows about our agreement, and yet you might have not released it.
There might be a blog post, a Facebook post, a Twitter,
a Medium post, yeah.
And that's the same thing. I'm going to kind of hop over back to the testing the waters materials. Getting your marketing folks on board is so key. We get comments from the staff. You have to file those preliminary materials, those testing water materials, as an exhibit to your offering statement. And the staff does look at that. They do read it. They do click through links. They do visit your campaign page, and they do Google, and they look at your website. So, you want to have your arms around your information so it's consistent. You don't want to have a press release on their website saying one thing and then put out some testing the waters material that says something different or contradictory. So make sure you've got your arms around that.
That's a great point. All right, so we're getting down to the end here. I want to ask your last remarks. I wrote it. I even circled it with Jim. I probably you're going to start with planning, but the closing remarks to you, and then we'll close out with Teresa.
So I would say a couple things. One, planning. You can never have enough of it, and you should be as organized as you possibly can. Plan for a lot more time. And then I would also factor in the calendar. Time of the year is also an important aspect. A lot of people misread that. I've written a couple articles about that are published. Feel free to look at those. So that also affects how things get done. I would also mention, we didn't touch on it, due diligence is not just data collection, it's data review and then data assessment. So a broker-dealer, much like a law firm, has to compile assessments of what we actually did receive. So we do have to write memos to files that says we did review this and we, et cetera. And now we're not going to opine on somebody's particular marketing thing. I mean, that's a business issue, but we do have to look at activities and opine and make statements and put active memos in our files that said we did review these. So I would just add that due diligence is, we kind of got off that, sounded like all we did is collect. We actually have to collect and review.
Perfect. Teresa, your last closing comments.
Thoughts. I understand that this is a large process, and because Oscar, you keep going back to our documentation. One, I want to encourage clients to please pick up the phone. If you are looking at this, if you're thinking about it, or if you've already started assembling the documentation, if you feel like you're not sure what's going on, I get it. If you're assembling all these documents and you have no idea why we're even asking for them, please pick up the phone, call us, and let us put it in context for you. An informed client who can help fend for themselves is the best kind of client. And so that I view that as very important. We have a lot of helpful materials on our website, so please jump on that and look at resources there. And just remember, it's not just about you, the issuer. There are other stakeholders, there are other people with interests involved. So always be mindful that, don't become so focused on what's going on internally. I know you're trying to grow a business and this is really important. You've got people you're trying to pay. You want to keep the lights on, but there are other people as well involved, and that helps to keep them on board so that they understand what's going on in the process as well.
That's perfect. And both of you have been great, because this is a subject matter that's very meaty. Nobody wants to talk about it, but we need to bring it out. And again, to help entrepreneurs, the audience. And I think it's good for the investors to know what goes into an offering before they invest. I think this is wonderful for them to know, wow, I didn't realize all of that. So people they're doing all that work for me. So when I'm getting there, it's saving me the time that I can just look at the offering. So great upside. Thank you both today for a great time. I'm looking forward to having you both back in again in different topics. But for everyone else, thank you very much for coming to the KoreSummit webinar series. Don't forget, you can go to the KoreSummit website. You can view the videos, you can share them, you can contact the speakers directly. Of course, you'll want to have confidential conversations with them, not with us, but great. We'll see you next week on Tuesday. We're on Tuesday, Wednesday, Thursday again next week with great topics. Have a great week, Teresa, Jim. Thank you.
Thank you all.
Thank you, Jim. Thank you, Oscar.
Thanks, Oscar.
This was great.
Bye.
Appreciate it.